Hey, what's up everyone? Today we're going to talk about the indoor management rule in company law. As you are aware, directors of a company have the power to bind a company. Some companies require a board resolution to affix the common seal on the agreement before the agreement is valid. But sometimes a board resolution is not passed. So the fixing of the common seal may be invalid under such circumstances. Also, a directors meeting to approve the entry into a transaction or a contract may subsequently be found to be irregularly held for various reasons. For example, the notice of the meeting was not sufficiently given under the Articles or the Companies Act. So outsiders have no way to determine whether the internal regulations of the company have been complied with. So therefore the law came up with a presumption of regularity. This is known as the indoor management rule, or the rule in Turquand's case, a very old case from the late 19th century, which set down this principle. So the indoor management rule, or the rule in Turquand's case, states that a party who deals with a company does not have to check whether the company's internal rules as to authorization of the agents, which include directors, have been complied with. Let me give you a local case as an example. Ko Nai Chai and Tong Lung Private Limited. Tong Lun is a company, so Tong Lun borrowed 200,000 from the plaintiff, who signed a loan agreement with Tong Lun. Negotiations for the loan transaction was conducted between the plaintiff and the managing director of Tong Lung on behalf of Tong Lung. So when Tong Lung defaulted on the loan and the plaintiff sued for the loan, the other directors of Tong Lung disclaimed knowledge of the loan. They said, no, we didn't know about the loan at all. And there was evidence provided in the court that Tong Lun always borrowed from banks and not from individuals. So Tong Lun argued that the managing director had no authority to contract on Tong Lun's behalf, the company's behalf. The court held that on the basis of the indoor management rule, the rule in Turquand, outsiders like the plaintiff do not need to satisfy themselves that the company's internal regulations have been complied with. Furthermore, the managing director had apparent authority to contract because he was the managing director, and therefore the court held that Tong Lung, the company, had to repay the loan. The new Section 25B of the Companies Act provides that a third party dealing with a company in good faith need not concern itself with whether the directors of the company are in breach of any limitations in the company's constitution. These would include any limitations deriving from a resolution of the company, or any class of shareholders, or from any agreement between the shareholders of the company. So for example, if the shareholders of a company pass a shareholders resolution stating that the managing director cannot enter into contracts above 100,000 Singapore dollars, and despite that the managing director enters into a contract more than $1 million, there would be no way for the outsider to know that there was this shareholders resolution passed to restrict the power of the directors. This new Section 25B is intended to protect third parties dealing with a company from any internal restrictions that may be contained in the company's constitution, which limits the power of the board to act on the company's behalf, provided that the third party has acted in good faith. For example, where a company's constitution contains a clause which requires the unanimous, that means all, unanimous consent of the board for contracts above $1 million, okay? And a contract of that nature was entered into without the unanimous consent of the board. That means say for example, the board consists of 4 directors. The constitution says that any contract above 1 million need 4 directors to approve. One of them did not approve, he was on holiday, he didn't sign the board resolution or what. But the counterparty would still be allowed to enforce the contract as long as he was dealing with the company in good faith. Section 25B(2) of the Companies Act provides that a person dealing with the company is not bound to inquire as to any limitation on the powers of the directors to bind the company or authorize others to do so, and is presumed to have acted in good faith unless the contrary is proved. English cases have stated that if there are suspicious circumstances or abnormal transactions, there may be an expectation that the third party dealing with the company is put on notice and therefore ought to make reasonable inquiries before entering into the transaction with the company. So thanks for watching this video on the indoor management rule.